The topic today that we were going to dive into is GDPR. And I presume everyone knows what GDPR is, although I did see somebody writing in notes in a session saying, what is GDPR? So we won't define it specifically, but we'll take the opportunity to share a little bit about what the spirit of the law and how we sort of interpret the spirit of the law, and then also more specifically the letter of the law, and how these gentlemen's various organizations and stakeholders that they represent have prepared for it and you know, got themselves ready for impending T-minus 10 days when the legislation comes into effect. So I thought, as I mentioned, sort of the discussions that would be good to start on sort of the spirit of the law rather than the letter of the law. And perhaps maybe talk a little bit about what we felt was the reason that GDPR as legislation has come into effect. And I think maybe Matthias could start, since you're holding the microphone, and then Doug, it would be interesting as well to share your point of view as well.
So GDPR came about, I think, primarily because the previous law has been really old. It was first created in 1995. That's the year that Internet Explorer was first released. So when we think about sort of the companies who process data, none of them really existed at the time. And especially, I think, advertising is in the debate of the GDPR always been something that came up, has really shown that maybe there needs to be an update. We need to kind of explain what some of the original intentions were a little bit more precisely to make sure the law keeps up with technology.
Yeah. And some of those intentions presumably are in the guise of consumer protection and looking out for the consumer. Doug, would you care to share?
The principle or the spirit of the law you really can't argue against. The idea is that consumers are entitled to control and to have some say in what happens with their privacy and personal information. And you can't really argue that point. If you're sitting in my role as someone who represents the evil brands out there who want to usurp all your personal identifiable information and cause you to purchase things you don't need, I would never characterize it that way. But in any event, it's hard to find that balance within that spirit. I'd add to what Matthias said is that, you know, one of the things that we realize in the States that we have to sort of confess is our fault, is that there was a thing called the safe harbors that were allowed for years. And so the idea was that we, you know, in conjunction and cooperation with the EU, we would agree as American marketers that we would comply with these safe harbors. So what did American marketers do? They all dove onto it, signed up and said, yeah, we're going to comply. Well, guess what? They didn't. It's so surprising. So in one sense, that also contributed to the need to tighten these regulations. And now sort of it's going to come to roost, depending upon what happens on May 26th. But the spirit was one thing. The execution is very much a different thing.
And obviously, the spirit is a very topical topic in the sense that we've seen a lot of data breaches and things happen, you know, recently and in recent time. And so, you know, I represent Adform in the Americas, based in New York, and the U.S. Looks to GDPR in sort of some sense of, you know, confusion perhaps, or European overreaching, but naturally, you know, as we see, you know, the news today and stories around Cambridge Analytica and how organizations haven't necessarily stewarded their consumers' data in the best possible way, it makes a lot of sense that GDPR as a legislation is coming into effect. So moving the topic of the discussion to sort of the letter of the law, I think it would be interesting because this is an area of lots of confusion, lots of different perspectives. I'd like to turn to Peter and Frederik to talk a little bit about how your organizations, who are obviously very consumer-facing and oriented organizations, are preparing for the letter of the law. So, Peter.
Yeah, so what actually happened when we first saw the drafts of the law, it was like Dr. Phil, where you have the shock, denial, and acceptance. So first we were very shocked that this can't be true. It went into denial and said that's not going to happen, it's not ever going to be there. And then the last 6 months it's been acceptance, the last and final stage of it.
Yeah.
The only way I prepared this day is actually to put on a T-shirt that says "We take your data personally," but. But we're actually the very definition of a middleman that has to do a lot on with the publishers and the clients. We need to make sure that everything is ready. We need to make sure that we have processing agreements with everyone. But the biggest issue that we're having is that it's sort of been, we've sort of been the go-to guys that our clients have asked, what do I do to uphold and to abide by the GDPR? And we've had so many questions that hasn't really been advertising related. It's what do I do with my email permissions? What about this tracking cookie, which is not something that we're working with on your side? So I think there's the confusion that set in there meant that we basically had to concentrate quite a lot of resources on understanding what it actually was. And also to be very clear with our clients that we do not give you legal advice, but we can point you in the right direction. Yep. And then it has been having discussions as to what they actually want out of all of this, which has also been tremendous fun for a lot of our clients. Yep.
Yeah, and just to add on that, Peter, I think the word acceptance from a client perspective is also central, because once you have the shock effect and that's done, you need to see yourself as a brand. Where do I want to lie in this mix? Do I want to get ahead of the curve and really embrace GDPR and do everything that I can muster of resources and really take this very personally? Because being in a very tight market with extreme competition, you need to be the one who excels at that. At least this is our approach. Being the ones who have to be ahead of the curve and internalizing all aspects of being compliant. So actually no consultants, no nothing. Really the ones who are living in this post-GDPR May 25th world will have to be the ones doing all the tasks. Mm-hmm. So we haven't been handed over a report saying this is how you should do and we'll do it for you so you look good. We have made everyone responsible for being compliant, because this is just the way of we have to live. Yeah. So accepting, yeah, and then defining where you want to go after that.
And if I can add to that, a few months ago, some of the discussions we were having with our clients is that this is actually a great thing, because finally all the money you paid to legal and lawyers, sorry Doc, it's not wasted. You have, the management is looking at this, so why not overhaul everything we're doing, ask for much better permissions, ask for design everything, so it actually is much better and much more consumer friendly, and much more consumer friendly way to work. So I think that many of the marketing organizations are actually doing that right now. They're saying that, so what we actually want to do with the data is this and this. And if they understand what the end customers want, and they incentivize them correctly, then I think that people will be okay with that. But right now it's sort of a scramble. How can we keep doing that, and how can we hide it in a text, even though they need to be active in their consent and all that? So this, I think you should embrace it fully.
Exactly. Yeah. And just the mere fact that there's no hiding from this, so let's just advance it. Yeah. To make it so visible that we are the best ones to take care of your data. And for the first time in many years, you're actually asked what you want, because we've never asked consumers how their data should be used or reused and used against or with them, and for what purpose. They've never been asked. So this is the first time they can actually take a stand and define what they want.
And
so
yeah. I think that's a great point, and one to expound on a bit more, which is first off the opportunity that GDPR presents to engage with consumers more proactively in the ways that data is being used. But before we sort of go too far in that, I thought it would be worth, for the audience's benefit, to just define a little bit more as to the two frameworks under which consent is provided. My understanding is that there's legitimate interest, and then there's explicit consent. And so, Doug, if perhaps you or Matthias wouldn't mind expounding a bit more on the specific letters of the law as it relates to consent.
Matthias, as I knows a greater depth on this than do I, but that is where there's a huge amount of confusion about the GDPR, the difference in the interaction between explicit consent and a legitimate interest. There are rumors out there that legitimate interest will be gone with the new e-privacy regulations, but in truth, that may or may not be the case. And what is and is not consent is as confused today as it's been for a long time. Whether or not this is cleared up with the existing e-privacy that exists or the GDPR or what the next coming, Matthias, where would you fall in that sort of dilemma?
So I would say this lawfulness of processing is a really great, step from the spirit of the law, because one of its roles is to make it possible for all of us to actually process data. Prima facie, it's prohibited to process any personal data because it is a fundamentally protected thing. So you need law that tells you under which conditions you are allowed to process. And there are 6 possible legal grounds for processing personal data, and consent is one of them. The legitimate interest is another of them. You could have a legal obligation, or you want to save the life of a user, of a data subject, then you also don't need to ask for their permission, for example. So there's many and often much more appropriate legal grounds for processing than there is consent under the GDPR. And then there is exemptions to that if you have sensitive categories of data like ethnic background or trade union membership and sexual orientation, for which you actually need explicit consent. Some of the legal grounds that we have for non-sensitive data don't apply in that situation, right? So all of them are equal. There is no hierarchy. Consent isn't better or king, as many consultants will say. That's not true. You look at what is the most appropriate in the given case. Sometimes that's consent. Sometimes that's legitimate interest, which can be anything as long as it's legal. The important thing is that you do this balancing act. How does this impact the user whose data I'm processing? And what am I doing, and where do we land? And if we land on, well, I'm not actually in the realm of their interests overriding mine, I can go and process. As long as I let them know what's happening, I give them the opportunity to object after the fact. However, this is where you mentioned, GDPR is not the only game in town. There's the e-Privacy Directive, also known as the cookie law, the existing law, which says where you are using cookies or accessing other identifiers, AID, IDFA, you name it, you actually need consent. There is no legitimate interest. So with our ecosystem, at some point the data will have to be collected over the internet, usually from a device. And at that collection point, you need consent. That's not optional. Right? Once you have the data, maybe you can use a legitimate interest to process it.
If I understand correctly, the e-Privacy Directive takes precedent over the GDPR where there's inconsistencies.
Correct. It's the more specific law, and therefore, in a conflict situation, it prevails.
So that would mean that the list of reasons why you don't need consent, including legitimate business interests that's in GDPR, is overridden by the current e-privacy regulation.
Where you are talking about collecting the data, right? Just at the collecting point. As soon as you have it and you want to generate an insight, it's just GDPR.
You can't do anything with it.
Yep, that's correct. But maybe you don't get it directly from the consumer, or you get it from an offline source. So that's sort of the things to consider there.
So in this, on this topic of consent, there has been just in the few weeks sort of a rise of a new 3-letter acronym technology platform within our ecosystem called Consent Management Platforms, CMPs, for those who are unfamiliar. Google has announced that they have their own. I think the IAB also is launching a framework. I would be curious for Peter and Frederik to talk about how your organizations are viewing it, and then also within the constraints of being legal lawyers, what advice you can give to the audience as to how they should consider these different frameworks.
So from an agency standpoint, one of our major concerns is that there is certainly 2 systems. One, I don't know if they've gone into the system as of yet, our friends from Google, but I think that is a very annoying setup for us. Also, a lot of the systems which are being introduced is also coming very late to the game. Yeah. So it's very difficult for us as an agency to understand what we should actually do and how we should do it. Yeah. And some of the stuff that has just come out, which had set some limitations, both for publishers but also for agencies, is something that we need to get our head around. But there's not that many days to actually do that. Yeah. So
can you just expand a bit more on the Google framework for those who are unaware? they just recently launched the consent,
Yes.
announced that they were embedding a consent management platform
Yes.
inside DFP with a limited
Yes,
number.
yes. There is actually a limited number of vendors which will be allowed within that consent platform. So basically, the publisher need to select which of their ad tech vendors can actually be on that list, and then it will handle the consent based on their setup.
Yep.
But I'm not, no, I don't know if there's any publishers here, but you can very easily count to 25 when you look at the ad tech vendors that you're probably working with. So there's going to be some problems with that. And what frustrates both us and the publishers is that it's come so late into the game.
Yep. Matthias, I believe the IAB is also has a consent framework as well. Is that correct? Can you...
I will say we were first. So we've been working for more than a year on figuring out together with our members what the GDPR means, and also with respect to transparency and consent, how to technically make it happen. And maybe it's worthwhile to take a step back and explain why we need a framework, because that's not necessarily obvious. The GDPR pretty meaningfully changes requirements around transparency. It's no longer good enough to say, we and undefined third parties are going to be processing your data. Are you cool with this? Right? You actually need to enumerate specifically each individual entity that will be processing the data on the basis of that consent. So that's why we need a whitelist. The publisher needs to know beforehand who's going to be processing their data, right? So sort of, let's send it out there and see what happens. That won't be good enough anymore. And second, we have this accountability principle, which means the regulator can come to any one of you at any time and say, prove to me that you are compliant. When you're processing data on the basis of consent, you need to demonstrate that you had consent. So it's no longer good enough to say, I have received an opportunity to bid on inventory, so therefore I am assuming I have had consent. You actually need a signal, right? Which is why we need some sort of communication channel. And that's why we need a framework, because we need to standardize how we talk to each other, what language to speak, what rules of grammar to follow. And that is what the IAB Europe framework is attempted to do in a way that is really open and industry-driven and doesn't impose any one company's legal interpretation on anyone, but just as a common language to communicate around user choices and transparency.
Frederik, it looks like you have...
I'm just elaborating on the role that the client can take, because obviously building your own consent management platform is obviously a solution, and also just owning the possibility of speaking in a very positive way to all potential customers and existing customers. I got a great email from Norwegian the other day saying, we have great news for you. I'll say, okay, what is this? Okay, for the first time you can actually control your own data and what it's used for. I was like, oh, that was actually the best mail I got all day. And us as a company sent a text out to our customers saying, okay, go in here and just check what you want and what you don't want.
Yeah.
So embracing that and owning that unique customer moment is everything is an opportunity. So GDPR for us is just a way to shine and be the best at what we do.
I love the optimistic view. So we're almost out of time. I'm sure there's some questions. So before we wrap, I just wanted to sort of open the questions to the audience and see if anyone had anything they wanted the panel to expand on. Anyone?
It's GDPR.
I guess we've done a great job then. So please.
Thank you. I just wondered what you think. I'm just curious. I mean, I'm not, as Doug knows well, I'm not very technical on this stuff at all. But what's actually going to happen? Are we going to see regulators start to attack like big business? I mean, are there going to be some scapegoats made example of? Is that likely to happen, or do we feel generally that it's quite encouraging and they're supportive and they appreciate this is difficult? Or do you think they will make an example of some big businesses just to make the point?
Yeah, you and I talked about this a few minutes ago. Here's the perspective from the state side. If nothing happens and we have a replay of the safe harbors, then it'll be another empty suit. So that being the case, I don't think that's going to happen. I think that the EU is going to want to make an example. Now, they can go after the usual suspects of Google and Facebook, but they're used to fighting them, and they've been fighting them since they were invented. The effective side here, if there's going to be a meaningful substance to this, is they've got to go after a brand. And who that's going to be, I don't know. But It'll likely not be the brand that at least tries to reach out to the folks who know what they're, we're putting something in place. But there's going to be a lot of U.S. brands that don't put anything in place because they don't think that they're subject to the GDPR because they don't think they do any business in the EU. And they're going to be the ones ultimately who are going to be the poster children on this. Why don't you talk about the other sort of aspect that we talked about earlier?
Don't just be afraid of the regulator. Be afraid of the user, because they can file complaints and every data protection authority will have to deal with the complaint. And if a user doesn't like what the data protection authority does, they will go to court like Max Schrems has done. And he's already started an NGO, and he's been raising a lot of money. I'm getting a lot of targeted ads to donate to his NGO, to go after companies who he doesn't consider are compliant. Maybe he's going to go after Facebook, which is his preferred target. Perhaps the regulatory authorities will continue chasing the big headlines, but really any pissed off user can go after any one of you. So it's important to have one's house in order, I think.
So I think just before we wrap, Doug sort of mentioned it a bit, but I'd be curious just to have the panel share what they think 10 days from now the world is going to look like with respect to GDPR. And so, yeah, Frederik, perhaps.
This is just a quote I got from a global holding company. They said, after the 25th of May, you don't want to be the slowest one to being chased by the big bear,
Yeah.
So just not be the slowest one. That was their strategy, at least.
I think that's a good.
Yeah, and also what's going to be interesting is if there's going to be a sudden last-minute panic, and then we get a call on the 25th saying, could you please hold our advertising for the next few days, so the slowest one will be caught, and then you can start again a few days later.
Yeah. Yeah. Well, I think this is probably the most optimistic discussion on GDPR that I've heard in the last 6 weeks, so it's good to end. It looks like, is there one more question? Sorry.
Yeah. I was just wondering, given that it's EU and it's, to my understanding, it's the local countries that are going to some extent, to enforce these rules, it's going to be different in each country. So what I've understood, the difference between whatever Denmark and Holland could be quite big in the way that it's being enforced.
You need to be friend with the interpreter.
On the 25th of May, which is a Thursday, the European Data Protection Authorities are going to come together and they're going to constitute the European Data Protection Board, which has a consistency mechanism where over time we will have common interpretations. And then, by the way, it's the weekend, so you have another grace period of 2 days. So maybe the advertiser will only come on Monday.
Advertising blackout for 3 days.
Yeah, exactly. Y2K again.
Y2K, exactly.
Yes, one more question.
Yeah. No, I just wanted to make a point because so it's not my organization, but a friend who does work at a smaller sort of startup, and just about the sort of joke we're making, right, about the 25th of May and pause. So they're already doing that, right? They've already been instructed. There are already agencies that have contacted them and said, can you stop the campaign on this date, just in case? This is a real thing, and this is affecting like revenue and people's jobs as well. So I don't know. I just want to
and I
make that
would
point.
say much more the sentiment in the U.S. is doom and gloom. There is a much greater sense of Armageddon, and that's why I made the comment that this is one of the more optimistic debates on GDPR that I've participated in. So. But yeah, I mean, that is very much the case, and many U.S. companies have pulled out of Europe as a result of GDPR and the risks or potential risks associated with it.
Well, they think they pulled out.
Yeah, they think they have.
I think realistically, not trying to be pessimistic or optimistic, just realistically, data protection authorities are not ready either, right? And they have come on the record and they've said they're not going to be chasing after big fines. What they want is people to be compliant. So as long as somebody has tried to do the right thing and they didn't get it right, they will probably have the opportunity to correct before they will be fined out of business, right? So I think the important thing is, even on the 25th of May, to continue achieving compliance even where it hasn't been achieved yet.
And on that note, I think we have to wrap. So thank you very much to the panelists, to the audience. Thank you for,